Ani Buju Tansi, my name's Kate. Yes, I'm a lawyer, please don't shoot me for that, but our firm works exclusively for Indigenous peoples, persons, and organizations across what some refer to as Canada. We do many different types of law and activism for our Indigenous clients, but our exclusive base are Indigenous clients. I want to talk to you today about consent, hope, and action. And this is my delivery to an predominantly, I assume, Indigenous audience. If I were speaking to a Crown audience, I would say the message CHA would be connect, hear, and accept from Indigenous peoples. But consent, hope, and action spells CHA CHA. And I used my Google machine and looked up what CHA, did it have a meaning, and it did. From Chinese, Tibetan, Hindu, Urdu, and Persian languages, it means via two roots. And I thought that that was perfect for a discussion of consent in the context of Canada. Consent, or the right to give or withhold consent freely, is the ultimate goal. Hope is the spiritual force that propels people toward that goal, and action is the means to get there. In Canada, CHA, or via two roots, means reinstituting the two-row wampum or two canoes path of decision-making. It is or should be a defining feature of the relationship between the two types of legal persons in Canada, Indigenous and settler, with settler being governed by the Crown. I will speak to consent first. What is it, and how did Canada develop so far away from two-root consent to one heavy-handed route of consent? Secondly, hope. How do we keep it alive? Through the 3 C's, curiosity, courage, and compassion. And third, action. How do we get back to two-root or two-row consent in Canada? Who acts or has to act toward consent, and how do peoples act toward consent? What is consent? In my world, as an activist lawyer, it is a right. It is effectively the same as the right to self-determination. Self-determination applies at the individual level and at the communal level, such as with a people. I, or we, determine for myself or ourselves how to think and feel about a thing and how to act on that thing. Do we accept it? Do we reject it? Do we fight it, or do we modify it? I am going to be talking to you today about picking up a fight. I don't necessarily mean by force. I mean, though, that the only way, in my view, that consent is actually going to become a reality in Canada is through fighting for it. It's not going to get handed over. And so I hope that at the end of when I'm done today, there is a sense of responsibility for exercising your right, and that you are somewhat more today motivated to do so. Because frankly, nobody else is going to do it for you. People can help, but it's your right. It is your responsibility to act on it. As for individuals, consent has been part of many laws and legal regimes for centuries. In the criminal law regime, we have the right to consent or withhold consent, for instance, to any sexual conduct. And if we don't consent and sexual conduct is perpetrated on us, it is sexual assault. That's just one example. In constitutional law, the right to life, liberty, and the pursuit of happiness in the US, or the right to life and security of the person in Canada. These are about rights or freedoms to choose what happens to us and what we do about it. As a right of nations, this has been part of modern international law, the right of self-determination, since World War I. It includes the right of state sovereignty and state immunity, the right for a nation to make its own laws and enforce its own laws internally without interference from other nation states. As a right of peoples that are not nation states, which is what we have in Canada, self-determination has been part of international law since 1976. It was not introduced with the UN Declaration on the Rights of Indigenous Peoples. It was simply made specific to Indigenous peoples, but Indigenous peoples are peoples. And the right of peoples to self-determination has been part of accepted international law since 1976. There are two instruments of international law that were passed in 1976, the UN Covenant on Civil and Political Rights and the UN Covenant on Economic, Social, and Cultural Rights. Article 1 of both says, all peoples have the right to self-determination, including the right to freely determine their political status, pursue their economic, social, and cultural goals, and manage and dispose of their own resources. As we all know, in 2007, the UN Declaration on the Rights of Indigenous Peoples became part of international law. Article 3 of that instrument also recognizes the rights of peoples, in this case, Indigenous peoples, to self-determination. And Article 19 uses the words of free, prior, and informed consent. It says that states or nation states, whether you like it or not, Canada is recognized as such on the international stage, shall consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions in order to obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. Canada has adopted, ratified all three forms of international law. The right is there. It's on paper. There are two limits to rights, including the right to consent and the right to self-determination. First limit is that no right ever at all is absolute. Rights of persons and of peoples can and do clash. When that happens, the clashing rights have to be balanced, and one or both will have to be limited in its exercise. For instance, an employer has the right to choose who her employees are, but that right is limited by the rights of others to not be discriminated against when making applications for employment at that company. They can't be discriminated against based on race, creed, color, sexual orientation, ethnicity, etc. So there are limits to rights. Same with the right to consent, and same with the right to self-determination, which are essentially the same thing. Second kind of limit on rights is that they have corresponding responsibilities in order to make that right real in practice. If a right exists only on paper and cannot be exercised in practice, it is all but meaningless. And I'm here to tell you that is still, to some extent, the state we're in Canada, and I'm hoping that we'll all agree to change that. It's what I'm about, and I'm assuming to some extent it's what you're about as well. There are two kinds of responsibilities attached to rights. The first is the responsibility of the rights holder, and second, the responsibility of the rights limiter. The rights holder has a responsibility to stand up and fight for that right, to be curious as to what that right is and how its exercise will affect others, to be compassionate about how it will affect others, and to be courageous enough to exercise it with compassion. The rights limiter is the party that holds power over the rights holder in any given situation and can or does prevent that right from being exercised or exercised fully. That limiting can happen through many means: laws of the rights limiter, force, like war, tools like money. The rights limiter has a responsibility, though, to exercise his power in a way that does not limit or limits as little as possible the rights of others. I'm not sure that we are seeing that occur in Canada. We are all both rights limiters and rights holders in any given time. It's not like there's a group of people over there who are always limiters and a group of people over here are always the holders of rights. We're all both. The question is, are we acting with courage, curiosity, and compassion in our interaction with each other? In Canada, there is a third limit on the right of Indigenous peoples to self-determine, to freely consent or withhold consent. And that limit is Canadian law. Canadian law does not yet recognize a right of Indigenous people to freely consent or not consent to any decision or action that could affect their self-determination. And as such, the right of self-determination in Canada does not yet really exist. It's on paper, but it has a long way to go to become real. This is exemplified by the fact that it took Canada, this great supposed bastion of human rights, 10 years after UNDRIP was actually in force internationally, to adopt it here. Canada fought its adoption. And then in 2016, May 2016, when Indigenous Affairs Minister Carolyn Bennett finally announced that Canada was going to adopt UNDRIP fully, she said, quote, "We intend nothing less than to adopt and implement the Declaration in accordance with the Canadian Constitution." In accordance with the Canadian Constitution is actually a limit on UNDRIP, FPIC, and self-determination. Possibly a very big limit right now. Because Canada's Constitution itself does not explicitly recognize such rights. What it does is divide all decision-making power and authority in Canada only between the two levels of Crown government, federal and provincial. And then with the Charter of Rights and Freedoms, allows individuals to check the power and authority of those two kinds of Crown governments. What is missing is any power and authority in Canada's Constitution of Indigenous peoples' rights, including the right to consent or withhold consent. So how did Canada, which started, its inception was to root consent, how did it become a place of such heavy-handed one-root consent? This is a story about the survival instincts of the imperial powers and settlers, of which I am one, being blown way out of proportion and used out of context. What is an instinct for survival and security quickly became greed for more and more. More land, more wealth from the land's resources, more power that land and wealth would provide. This, as we all know, is the story of colonization. bear with me because I'm going to write some letters on the flip chart. I'm not going to draw pictures, thank God, because I'm a terrible artist. I have spoken about this in decolonization workshops across many parts of Canada. The history of Canada to date, from what I understand to be Indigenous perspectives, is a history of setback. And that's my acronym. But there are stages of the relationship, the legal historical relationship between the Crown and slash settlers and Indigenous peoples that can be reflected by these 7 steps that spell setback. The first is this. The first step is prior to European contact. Prior to the white man coming over here, my understanding of Indigenous history is that Indigenous peoples were living by sharing survival, what is also known as survival by the circle. It's sustainable. All things are connected in life. All things, even rocks. Each has a role to play in life. There's no break in the circle. We are all one. We're all connected. And it was sustainable for millennia. Compared to the Euro-Canadian way of thinking and acting, which is very linear. European way, or the white man's way of thinking and acting is a line, and it's a top-down line. It means that there's somebody or something at the top, but then that also means there's somebody or something at the bottom. It's a worldview of domination, exploitation, and subjugation, ultimately. That wasn't here prior to contact. When contact first occurred, and I'm way, way oversimplifying, and I mean no disrespect to do so, what are real, living, oral histories. I'm condensing this because of the format we are in. The second step in the legal historical relationship between the Crown and Indigenous peoples is equality. When governors and so-called explorers came to Canada at the behest of their respective crowns, Dutch, French, and English predominantly, they were instructed to, and in fact did, honor and respect the Indigenous peoples who were here as nations. Frankly, they had to in order to survive. For the Europeans, this was a vast and potentially hostile land in a climate they didn't understand, with species of animals they didn't know. And in order to survive, they had to acquire the consent of the Indigenous nations who were here, sit down with them around council fire. And the concept of the Silver Covenant chain, ask for permission to use some of the land, ask for permission to be here. And at council fire, they had to earn the trust of the nation, the Indigenous nations leaders who were present in order to stay. Many governors were ousted from what was then North America, became Canada, because they were not, in fact, trusted by the Indigenous nations leaders who were here. There was a real sense that the Crown knew it had to get Indigenous nations' consent and that it had to earn that through trust and respect. And so the initial treaties, which is step 3, were in fact treaties of peace and friendship, treaties of alliance. The Crown would be an ally of a respective Indigenous nation with whom it treated in order to protect and respect each other's rights and interests. Those were the initial treaties. The Crown came asking for permission. They were granted that permission from the Indigenous nations who were already here. And I wanted to spend a moment talking about treaty rights for a second. Unlike what the Crown and some flawed Canadian courts have said, treaty rights are not grants of rights to Indigenous peoples from the Crown. It's the opposite. Treaties are grants of rights from Indigenous nations to the Crown. It can only be that way in Canada. Why? Whoops, I can't spell. That word inherent. Indigenous peoples, by virtue of always being in here, look at the word inherent. Just an elongated way of saying in here. Indigenous peoples have always been in here, in this part of the world that the Creator put your peoples to survive and ensure the survival of. Those rights are just simply called inherent rights under international and Canadian law. They derive from always being here. Your attachment to your land, the resources that you are to govern, are called inherent rights. You had them. You didn't have to get them from anybody else. The Crown, since they came from elsewhere, had to get them, and they had to get them from the rights holders who were here, which are the Indigenous peoples. So treaties were the Crown seeking permission or consent from Indigenous peoples to be here. And as I said, the initial 1700s treaties between the Crown and Indigenous nations were clearly in their written text treaties of peace and friendship. They were permission for the Crown to be here as long as the Crown behaved respectfully and in a trustworthy manner. But as we all know, treaties morphed into, from the Crown's perspective, and only the Crown's perspective, treaties of cede and surrender. So between the 1700s and the early 1900s, something happened to cause treaties to be true two-route consent treaties to being instruments of subjugation by the Crown. I know and you know that from Indigenous people's perspective, even these more recent treaties, the numbered treaties, are not really ceding and surrendering anything because your laws, Indigenous laws, would never have allowed that. But Canada, or the Crown, put that language in there and then used that language and uses it today to say that you gave up all rights, title, and interest to the land and the resources, your land. What happened between the late 1700s and the 1900s is that Canada, the Crown, no longer needed Indigenous peoples as allies and protectors anymore. The settler population came to outnumber the Indigenous population. The wars between the European powers themselves in North America ended. In fact, the last one ended the War of 1812 to 1814. And after that point, 1814-ish, the Crown set about to use treaties as an instrument of subjugation. It is the great duplicity, the great fraud in Canada's legal history. I absolutely know and respect that treaties are sacred to many Indigenous nations, but your understanding of treaty is what I believe to be sacred. That these were just more of two-route consent. That the treaties were to be, I give you consent, Crown, and the people you govern, the settlers, to share in the use of the lands and resources that were once entirely yours. We have a long way to go to correct this. It is still in Canadian law that this interpretation of cede and surrender is what they really mean. So we have to fight it. Where am I? Fourth step. Betrayal. So the treaties began the betrayal, and then Canada perpetrated it even further with the Indian Act. When I say betrayal by the box, the intent of the Indian Act was to box Indigenous peoples in to tiny little reserves and to rely on the cede and surrender language in treaties to say you really have no rights outside of the reserves. A, the 1, 2, 3, 4, 5, fifth step. Treaties of cede and surrender from the Crown's perspective, betrayal by the box, were attempts to annihilate and then assimilate Indigenous peoples. These were, don't kid yourself, these were deliberate policy directives of the Crown. They did not want any separate peoples or nations within the four corners of what became Canada. They wanted, it was okay that you were darker skinned, but they essentially wanted everybody to become white people. Annihilation attempts were real, and you probably know them better than I do. The story of the smallpox treaty blankets, the wiping out of the buffalo. You were supposed to be gone. And then when annihilation became too un-PC, the Aborigines Protection Society in London, England, for instance, started to complain about some of these actions being taken by the colonial powers over here to kill. Then the method switched to assimilation, which is harder to see, right? It's like toxins in the air. You can't see them, but once they get into you, they're just as deadly. Indian Act, big method of assimilation, but not the only one. When you think about worldviews, cultural perspectives, laws, all became instruments of assimilation. Sixth step. It's a difficult one, but I believe in your hearts you know that it's happened. Cooptation. It means when assimilative forces become internalized. It is human and perfectly understandable and acceptable that all of the pressures on peoples from assimilative measures, some of them become internalized. You become changed. It would be extremely odd if it weren't that way. And so the stories that I've heard about people feeling disempowered, communities and nations feeling disempowered, is a story to some extent of cooptation. And then the last step, we're not done, but the last step into the point where we've gotten is that? Kill, cultural genocide. It has been widely recognized in various forums in the US and marginally by the most recent federal government in Canada, that the effect of all of this has resulted in cultural genocide, which is a form of killing of a people. That is thankfully not the end of the story. That is simply what's happened more or less to date. What I'm here to talk about is the work to be done to get back to consent, to get back to here. I want to talk to you for a moment about hope, and just for a moment. I mentioned the 3 C's: curiosity, compassion, and courage. To me, that is hope. If at all times one acts with curiosity, what is this? What will it do? How will it affect me? How will it affect others? And then compassion, caring about how it affects me and others. And finally, courage to do the right thing. If one acts that way, hope will remain alive. Because when hope goes, frankly, everything else does. All right, action. How do we get out of this? I want to talk about the who before I talk about the how of action. Hang on. I have another 7-letter acronym, so. On who, each person and each collective, including a people, is responsible for upholding his or its or hers own rights and not unjustly limiting the rights of others. Again, we're all rights holders and rights limiters at any given time. Your rights are your priority. And I hate to say this, but it's true. They are not anybody else's. It's life. It's not fair, maybe, but it's life. It doesn't mean others shouldn't and won't help you. Not at all, but it means the genesis of standing up for, with courage, compassion, and curiosity, one's own rights has to come from oneself. That is my understanding, at least. We know what a person is, at least I think we do. So rights reside in persons, in individuals, but as I said, they also reside in peoples. What is a people? And speaking for a moment as a lawyer, there is no one agreed upon definition of a people in international law. There's no easy answer to that. And again, it is a people that is the holder of the right to self-determination. So it's important to know what a people is, because that is the collective in some legal instruments, and very important ones, including UNDRIP, that holds the right to self-determine and to consent. I can tell you this, at least speaking as a lawyer. Being a people requires 4 things: a common culture, a common set of laws or moral principles, a population that self-identifies as part of that people, and 4th, the capacity to be responsible for exercising that right to self-determination, which means the capacity to self-govern. What it does not require is to be a nation state like Canada. Many peoples can exist within or across the boundaries of nation states. It is also an axiom, I think it's true, that all peoples must evolve or adapt to survive as a people. Adapt to changes in the physical environment, changes in and pressures from world developments in law, politics, trade, economics, etc. So the question is for you, in Canada today, what are the Indigenous peoples who have rights to self-determination, to consent or withhold consent? And in relation to who or what? Pardon me. What were large Indigenous peoples before the interference of Crown and settlers have in many cases been divided into smaller entities. Canada calls bands under the Indian Act. Some call First Nations, others call communities, sometimes they're called all three. No people could survive the onslaught of all that has happened in Canada and still come out looking exactly the same at the end. There have been changes. You're experiencing them. But what does it mean about the right to self-determination, to consent or withhold consent? I'm not going to try to answer that for you. I mean, is a First Nation, is each First Nation a people with the right to self-determine? The answer will be based on whether the four required elements of being a people is there for any First Nation or any larger collective. Again, repeat those four requirements: a common culture, a common set of laws, and I'm not talking about Canadian law, or moral principles, a population that self-identifies as being part of that people, and the capacity to self-govern. I tend to believe that as things occur and evolve over the next several decades, that the key question in who are the peoples, Indigenous peoples with the right to self-determine, will largely revolve on the fourth point. Who or what has the capacity to actually self-govern, not on paper, in practice? That takes a level of administrative, political, economic, and factual authority and power, and I don't mean power in a bad way, to be able to run a government. I actually try very hard, by the way, to not say the term the government. There's a Crown government, and there are Indigenous governments, which, again, will evolve as self-determination becomes real. But the who, I think, is going to evolve. Who the peoples are going to evolve. And so, how do we get to consent? I believe, and again, look, I'm just one person. I've been doing this work for a long time, but as was said earlier, I have, and always will, much more to learn than I ever know in any given instant. And so I'm one person partway through her lifelong journey, maybe more than halfway through, but, and so currently, my view based on my lifelong learning, particularly from Indigenous persons, peoples, and organizations, is this. that in order to get to real effected consent and self-determination for Indigenous peoples, probably going to have to be some unification, some combining. I'm not suggesting anything other than that, but the practical reality, and again, a right on paper doesn't really mean very much until it becomes real in practice. And for self-determination and consent to be really effective and in practice for Indigenous peoples, I think there may have to be some of this. If a First Nation or a band or whatever the appropriate terminology is of a few hundred people is going to attempt to effect self-government in practice, I think in many cases they're going to have some difficulties unless there's some unification in perhaps a larger entity. As it was before, there were regional governments, Three Fires Confederacy, there were nations, Anishinaabe Nation, and there were bands or clans or family collectives that carried out a lot of the direct interactions with the land. So as it was before, may have to become somewhat that again. And then I believe there's going to have to be organization, and here I am speaking about for external campaigns. And I come back to the point that while rights are yours and they're going to be your priority doesn't mean other people aren't going to care, but first top of agenda are going to be yours. You absolutely can and should seek support of others. I heard, I listened, our firm heard, we continue to listen. I hope that we are supportive, but many other people out there will be if there are organized campaigns, advocacy, media, legal including case law, litigation, and support building. These are measures to get the message out and to bring help and support in as you want it. N is nation building. And I mean here not just the structures of government, your government, but all four pillars of being a people. And in this context, I'm using nation not like it is in international law, meaning a nation state or what we call a country, but a nation, as you certainly were before the Crown and settlers came. All four pillars, rebuilding those, because much has been done to harm them. Culture. Common culture is the first pillar. Education, your educational systems. Your telling of history through your truth. Those are forms of rebuilding your culture. The second pillar of being a people is law, common set of laws, or moral principles. Indigenous laws, to my knowledge, I have never met a client yet who told me they have no more of their laws left. You know, creator's law, also, from my understanding, called customary law. Your unwritten constitutions are customary law. Those are there, but they need to be built up again and built upon with more myriad laws today, that again, all peoples, I believe, have to adapt to survive. So your laws will have to adapt and expand probably to deal with the more complicated things that exist in modern day. The third pillar is population. Citizenship laws, your citizenship laws. One method of building a self-identifying population. And that's not an easy task, but communication, reaching out, sharing circles. There are methods to build a self-aware and self-identifying population. And the fourth pillar is the capacity to self-govern. And that is the development of systems with human resources and financial resources to run government. Your government, not the Crown government, yours. Fourth, sharing agreements, what treaties always were supposed to be. Renewing historic treaties that have been co-opted by the Crown and bastardized into cede and surrender, take them back. With the Crown, those would be renewed or new sharing, mutual, two-route consent treaties. They absolutely can and should be negotiated today. With proponents, there are already a whole bunch of laws between proponents and Indigenous communities or peoples for mutual two-route consent there. Those are called impact benefit agreements. It is what Emily Martin spoke about as well with proponents. Those agreements are laws. They are the law between the parties to the agreement. And when you have proponents, mining companies, exploration companies, hydro companies, et cetera, who want to do physical or other development on your lands, you pass a law, if you agree to it, setting out the terms and conditions by which you will consent to that happening. And when they sign the agreement, they're consenting to carry out their project in accordance with those terms and conditions. It's a form of law. Build on that. Use that as one minor example of how to build mutual two-route consent sharing agreements again with the Crown. I know money is a loaded term, and I know that money can change people and communities. But it is the method of trade globally. It is the method by which we acquire other things and give away or sell other things. It's a reality. And so when I talk about economic here, I'm simply referring to that reality. The reality that you have to pay staff. You have to pay for overhead. You have to pay for community engagement. With what? Unless you have a bunch of IBAs and other agreements where you're getting very good revenue sharing from various developments on your lands, many First Nations still don't have a lot of this stuff. The second word I put here is restitution. Acquiring money from the Crown, in my view, all of it is restitution money. The Crown has stolen lands and resources without color of right for the last 150 to 200 years. By the Crown being compelled to give it back, it is a form of making restitution for the wrongs done. In my personal view, there is absolutely no shame in demanding money from the Crown as restitution. It isn't a handout. I totally understand that the systems Canada and the provinces have created have caused a puppet string dependence. That's horrific. What I'm talking about is something different. Demanding money as a form of restitution, litigating and fighting to get it. Six, the N is for neutral dispute resolution, at least for the short to medium term. Right now, decision makers between the Crown and an aggrieved party are Canadian courts and Canadian tribunals. They are part of the Canadian governmental system. It isn't neutral at all. There are models in international law, like international commercial arbitration, where there is actually a neutral third party with no vested interest in either parties to the dispute, who makes decisions under a set of guidelines or rules. And I am proposing that bringing in aspects of international law when rebuilding a two-route consent and self-determination regime with the Crown in Canada will probably require neutral dispute resolution, and there are tools in international law to take advantage. Last, but by no means least, is take it back. I am a cynic. I do not believe, unfortunately, that it's going to get gifted or given. I think you're going to have to take it. Through all the means that I have set out, and many, many, many others, I think it is up to you, your governments, your peoples, to stand up and take it back. Miigwech. I don't know if anybody has any comments.
I'd like to take the opportunity to field any questions out there. Does anybody have any questions for our lovely speaker that's here with us today?
I have a question.
Okay. No cheating, eh?
Oh, I recorded the whole thing. Oh, wait, I forgot my question now. Hang on. It'll come to me in a second.
I like the way you use the acronyms there. I have that effect on ladies. Sorry. My wife says I'm pretty powerful. I think she's talking about the odor. Yeah. Hop. Sydney.
Yeah, I just wanted to say that's probably the best history lesson that I've ever been taught, and I can see the benefits of using that as a tool to teach the children, because in grade 7 and 8 they would fully understand it.
Awesome, that's right. sorry. He always calls me. Sir, can you move to the front, please? No, I'm just kidding. Yeah. I got to get my steps in. I'm just kidding. Shagadinin, I'm just teasing you.
I know 15 Iroquois Confederacy members that are trying to get to The Hague, the International Court of Justice. They won't be, the United Nations won't speak with them. The Hague will only speak through emails saying, don't bother coming. Can you get them in?
I don't know, is this working? Yes, it is. The entire human population has been on the planet for a small blip of time. The changes since 1982, when Canada's constitution was repatriated, is a microsecond of time. It will take concerted, organized, combined effort and some patience and not losing hope and leadership to do that. There are many mechanisms. I wrote a strategic paper for the Haudenosaunee Confederacy Council when I was on the reclamation lands several years ago that contains many of those tools. I would have to reinvigorate that, but is it easy? No. The current state of international, nothing I'm saying is easy, by the way, and I don't mean to paint the portrait that, this is all going to happen tomorrow. Of course it won't. But in the history of human beings on this planet, it's still, these things are happening relatively quickly nonetheless. I know it doesn't feel that way. There are a number of tools or mechanisms in international law that people haven't been using that are available to be used. I'm not saying it's just going to happen. The louder you get, the more organized you are in a concerted and organized way, eventually you will be heard. But the current state of international law says you have to exhaust domestic remedies, which means you have to go all the way through the court system in Canada before they'll hear you over at the UN at The Hague. Okay.
Well, they have gone through the Supreme Court of the United States and were denied certiorari. So they've done that.
Okay.
And it seems to me the Declaration on the Rights of Indigenous Peoples, in the United Nations' own words, allows them to proceed in the International Court of Justice at The Hague because it highlights, at a bare minimum, all the spectacular rights that Indigenous peoples have, particularly the right of sovereignty as an individual. And that's what these 15 people are relying on, that declaration. And I think it deserves at least a hearing rather than the registrar's office saying we don't give legal advice, but don't bother coming. I mean, that's in my view, unconscionable.
It is, as is the history of Canada, unconscionable. There's no easy answer to that. One of the things I have advised another client to do in another circumstance is find an international sponsor. I know it is somewhat, well, more than somewhat, it is annoying and perhaps even somewhat degrading to have to find a nation state as a sponsor, but we are exploring that in another environment. I can't give specific answers to a specific situation with which I'm not familiar, but there are some mechanisms that'll have to be hard fought, though.
How would that other state have standing?
Say again?
How would that other state have standing to assist? I don't.
As a sponsor.
As a sponsor. Thank you.
Okay.
Okay. Neat wedge.